Good afternoon, everybody, and welcome. Thank you for joining today's session. We're going to split this into two different sections today. In the first section, we'll take a practical look at how the recruitment and umbrella sectors have responded in the first few months following the introduction of JSL. It's not going to be a theoretical discussion. We're going to be sharing what we've actively seen in the market, what behaviours are genuinely changing, and where challenges still remain. And then in the second section, we're going to take an in-depth look at the Employment Rights Act, and particularly the recently launched consultation, which is around ending one-sided flexibility and all around those 0 hours contracts, and what that's likely going to mean in practice for agencies and end clients. First up, I'll do some introductions. I'm sure most people on here are aware of who I am, but for those that aren't, my name is Alex. I'm the CSO over at Sapphire. I've got three expert panelists here with me today, so I'm going to hand over to them to make those introductions themselves. Hannah?
Hi everyone, I'm Hannah Morrison. I'm a partner at Brabner's, which is a law firm based in Manchester. I'm an employment lawyer and I specialise in advising businesses in the recruitment and workforce solutions space, so from umbrella companies right up to master vendors and end user clients.
Lovely. And for you, Charles?
Yeah, I'm Charles Harradine. I'm the Director of Strategic Partnerships at the Casing Group. We specialise in healthcare, workforce and services. And in our business, we have the straight staffing agency business. We also run MSPs and we also have services businesses as well.
Perfect. And last but not least, our newest recruit here at Sapphire, Chris.
Thanks, Alex. Yeah, so I'm Chris Blow. I am the Director of Compliance, newly Director of Compliance at Sapphire. I have been in this industry for my since 2002, so been through a whole raft of legislative changes, and largely supported, I would add, by Hannah for most of that. But yeah, thank you everyone for joining today.
Amazing. So first up, I'm sure everybody's probably a little sick of talking about it, but joint and several liability. We are going to have a reflection on what's gone on over the last 90 days post those changes actually coming into effect. We all know that JSL has fundamentally shifted liability across the supply chain. Compliance is now in real time, and organisations are having to balance compliance expectations, financial stability, and commercial pressures. Chris, like I said, I accept that most people on this webinar will know about JSL by now, of course, but can you give us a quick summary of what you've seen over the last 3 months post the implementation?
Yeah, no problem. I mean, just prior to the implementation, it's pretty important to kind of outline that there was a lot going on. We saw agencies, MSPs, the larger ones, I may add, kind of collecting data from umbrella providers, from a compliance perspective, from a financial perspective, and then making decisions with regards to PSLs on the back of that. So there was a large kind of condensing of PSLs, which kind of resulted in roughly the same companies, being found on each of those PSLs. The precursor, in most cases, was kind of an FCSA accreditation and a safe rec, and to some extent Veripay kind of backing as well. So we have seen, I would say, that JSL is working in my view. We have had conversations with HMRC where they haven't as yet collected any real data. It's a bit too early for that, but their view, I suppose, is that there's been a change in behaviour, in attitudes towards due diligence. And from figures wise, we have seen, and again, it's limited data, but approximately 20,000 or so directly new individuals coming into the compliant end of the market. And what I mean by that is that those companies that are FCSA and SafeRec accredited roughly have had that figure. Now, that's not the full picture, I may add, because the figures don't take into consideration companies that became accredited after kind of January. So we could be looking anywhere up to, 30, 40,000 new people that have come in there. Pleased to report that Sapphire have grown and done extremely well out of that. I think you know the figure better than me, Alex, but I think it's roughly 25% growth from our perspective. But we have seen, and I think we kind of thought this would be the case, that, the smaller to medium-sized umbrella companies that are not on those PSLs largely starting to kind of struggle, and we've already seen some one particular casualty in the market there as well. As I mentioned before, the engagement has been largely with larger MSPs and agencies, the smaller ones not necessarily fully engaged yet. And for conversations that you'd have within the industry, the feeling there is possibly down to HMRC not really getting that message out strong enough to those providers as well. But yeah, overridingly, it seems to have worked. I think there's a bit of a journey still to go on with certain providers, though.
Yeah, I think that's seen, isn't it, by that increase of 20 to 40,000. That
Mhm.
is probably a slightly smaller number than what everybody anticipated.
Yeah.
But in what you've just said, there probably, whilst a lot of work has been done, there is still a little bit more to be done in the market.
Definitely.
Charles, how did MSPs like Acacian plan for joint and several liability, and what has been the impact on your business so far?
Yeah, I guess we started our journey prepping for JSL probably in February 2025. We tried to get ahead of it as early as possible. We saw, working in the healthcare space, there are probably some greater challenges around tax avoidance, and we'd seen that in the healthcare space, and we had escalated that to sort of HMRC and the frameworks and flagged those issues. So we had already sort of started to prep our supply chain for the change, and we actually went live with a sort of semi JSL compliant PSL. And what I mean by that is we'd already strengthened our governance and controls and looked to ensure that PSL was SafeRec verified. So, and we pushed that down onto our secondary supply chain in preparation for the JSL impact to the MSP, where we were due to take on more risk. And what that allowed us to do was almost ready the supply chain for the change. There's obviously a lot of upheaval where candidates have to move umbrellas, and we had already sort of put those wheels in motion. And what that allowed us to do was really, by the time we got to April 2026 and the go live date, was refine that umbrella PSL, tighten our controls around auditing our supply chain, removing sort of higher risk suppliers where we felt it was necessary, and also starting to build better partnerships with the umbrellas, like yourself, Sapphire, who's on our PSL. We felt that really just increasing controls and governance wasn't the only way to manage that risk. It was through a partnership approach, through our supply chain, for our agency suppliers and the MSP, for our umbrellas as well, and just making sure that everyone understood the change, and everyone was working to manage that risk as best as possible. And we, what we really did from the outset was we didn't treat this as a narrow tax technical change. We treated it as a supply chain governance issue. So we looked to control that across various work streams, and so we had our legal team involved, we had our supply chain team involved, we had our operations team involved, we had our payroll team involved, and our compliance team. And we set up some pretty in-depth work streams and mapped everything out that we thought would happen, built the controls, and then shared that with our supply chain and our umbrella partners as well. I think, go on, sorry, Alex.
I was just going to say, has there been anything that's been particularly difficult? Has there been any negative fallout on your business?
I think there's obviously been an increased governance burden. So there's a lot more activity in the MSP now around the auditing side of things, but that's been helped through some of the advancements that have happened with SafeRec and the technology they've put around. So it's not all been down to the MSP to manage, but we've had to invest time in our review of our contracts, review of our processes, getting better data as well. So building out dashboards for our payroll systems and linking that to SafeRec as well, to fully understand what's happening, when's it happening, and to highlight risks. I think the biggest change in our organisation, and I suspect across the wider market, is that cultural change around JSL, and the fact that actually there is a liability now that works up the supply chain, and it needs to be considered, and just making sure we instill that culture across all of our back office and front office to make sure that we're and our supply chains to make sure that we're in the strongest position possible, but also at a board level as well. Our whole board has been behind this and wanted regular updates as to how we're operating, because as an MSP we've just taken on significantly more risk under JSL.
Yeah, and obviously as a group you're running MSP and day-to-day recruitment solutions, right? So
yeah,
I suppose was there slightly different challenges in each of those particular parts of the group? Was there anything that stood out?
Yeah, I think the biggest challenge, MSP versus staff, our own agency business, is in our own agency business, we've got 100% visibility of the data that's happening, and we can easily access that. With using secondary agencies or a supply chain, you're reliant on getting access to that data, whether that's through SafeRec, and then there's some issues around, you know, standardized naming conventions, etc., and being able to use that data en masse. And really, when you can control it in your own staffing business, you can ensure that data is clean and regulated. I guess you lose that control a bit when you use external providers. And I think that comes back to the partnership approach, really having strong partnerships with key umbrellas, key suppliers, and not having huge PSLs. Having those really tight partnerships means that you can work through those problems in real time almost, and everyone's working to solve that issue, those issues around the sort of data visibility.
Well, makes sense. Hannah, for you, what's your view on how the supply chains reacted? And specifically, are you seeing any of the inevitable, we've got a way around this proposals that usually come out after legislations change?
Yes, you won't be surprised to learn that I am. Generally, I guess I come from a slightly different perspective because I don't have access to the same sort of data that Sapphire has and as an umbrella, or that you have as an MSP. So my kind of perspective is a little bit more anecdotal, I guess, in terms of the conversations I'm having with clients across the supply chain. Generally speaking, I think, the compliant umbrella companies, so FCSA and SafeRec accredited umbrella companies, have been on this from the offset and wanting to, be proactive and transparent and give comfort to their sort of supply chain partners. And equally, those supply chains that have an MSP in it have been, ahead of the game and ensuring, proper due diligence and flow of data. Supply chains that don't have an MSP in them have not been as aware of the changes and the impact of them, particularly smaller agencies I came across in literally the days leading up to the 6th of April, who just didn't know what JSL was, hadn't taken any steps to deal with it. That's at an agency level. At an end user client level, broadly speaking, they are completely oblivious to JSL. I've spoken to lots of clients within our firm who have temporary workers in their business, and they were unaware of JSL. They were unaware whether those temporary workers are, simply supplied PAYE by an agency or whether there is an umbrella company in the chain. And obviously, in certain circumstances, the end user client can have the joint and several liability. So I still think there is a huge education piece and actually an opportunity for the supply chain, for MSPs, but also for agencies and umbrella companies to sort of get out there and educate the chain and educate end user clients about this and about their potential liability, but about all of the good stuff that you're doing to try and mitigate that. As you say, Alex, usually when there is a change in legislation that imposes some kind of liability on someone, there is someone else who turns up selling you a model that is the answer to all your prayers, and sort of takes you completely out of the risk zone. I'll give you some free legal advice. Generally, if it looks too good to be true, it usually is. One of the models we've seen in the last couple of months is something called a bills of exchange. I don't know if anyone's come across that. These models are quite often touted with some sort of obscure barrister's opinion, saying it's all legit, but bills of exchange have been referred to by Dan Needle, who's quite an interesting chap on the subject of tax. It'd be worth giving him a follow. And he refers to them as magic beans, because it is like paying your PAYE bill to HMRC with magic beans. It dates back to some sort of archaic legal principle that if you go to HMRC and give them a note that's been sort of authenticated by someone that says, I will pay my PAYE debt, that they have to accept that and no money actually changes hands. I mean, it's nonsense. Um, and what was really surprising actually with that is that within a few weeks, really, of that model really sort of kind of coming through into the mainstream and being talked about, HMRC were on it and had issued a statement saying, as far as they were concerned, that was a form of tax evasion. I mean, historically, when you look at their approach to mini umbrella companies, for example, mini umbrella company fraud, it took them years really to sort of get their head around it and set out their position. So they're clearly alive to these sort of avoidance mechanisms, and that, they're prepared to sort of step up and say, if you use one of these models, do so at your own sort of risk, because as far as we're concerned, it's tax evasion. So there are also sort of other models out there which kind of purport to take you out of the JSL space by, I don't know, paying people on an inside IR35 basis. So you pay them through their limited company. You deduct PAYE, so HMRC are happy, but you're not giving them the corresponding employment rights. And generally speaking, if someone's inside IR35, so a deemed employee for tax purposes, they will almost always be an employee for employment law purposes as well. So they should be getting, holiday pay and all of that. So yeah, be aware, be aware of these models out there. As I say, broadly speaking, if it sounds too good to be true, it generally is. So just be alive to that. I think at the end of the day, and I think we'd all agree on this, there's no substitution really for just proper detailed due diligence, understanding your supply chain, and doing this on a regular basis. It's not good enough to do it, once prior to 6th of April. This is now going to be an ongoing thing, and compliance is well, it's a USP, but it's not just a sort of a kind of bolt-on benefit anymore. It has to be the norm for any businesses operating in this space.
Yeah, but when I first saw the bills of exchange suggestion, I just, it's almost a bit laughable, isn't it, that that is actually something that's been put out there by professional people. Well, you'd think professional, but probably not in what they are doing. Yeah, it makes absolutely zero sense. But there we go. I suppose we know that with any legislation and compliance changes, they do tend to bring operational challenges. So far, where do you think that JSL is proving difficult from an operational point of view for recruitment businesses and the rest of the supply chain?
I think it really depends, as Charles already alluded to, where you've got a kind of sophisticated supply chain, particularly one that has an MSP in it. I think the operational challenge has just been the volume of time and, the sort of associated cost really of this level of due diligence and compliance, and looking at your PSL, looking at sort of for umbrella companies getting things like FCSA or SafeRec accreditation, compliance costs money, and it's only one of the cost increases that we've seen in the last sort of 12 months, and yet we're not seeing sort of assignment rates at the client's end of the spectrum really increasing. So cost is really a challenge. And I think for other businesses that are, in less sophisticated supply chains, just getting their head around the legislation, trying to work out what to do. There were some agencies that I spoke to who were sort of quite keen to move away from umbrella companies, but then you've got the challenge of, doing payroll in-house. Payroll is a really sort of specialized activity. It's not just punching in a couple of numbers and clicking a button. So just practically how to deal with it has been a challenge for some businesses.
The PAYE point is interesting because obviously that they were the options, right? Compliant umbrella, or sometimes, direct PAYE, because a lot of businesses offer that route. I suppose as we come on to the Employment Rights Act in the next section, there are still those two things fighting against each other, which I know we've spoken about previously between us. Charles, do you think we're seeing what we expected to see following the JSL changes? And do you think that there's going to be any more changes to the sector in the coming months?
Yeah, I think to a degree, we have seen the sort of the changes that we expected. So what do I mean by that? MSPs have tightened controls, especially sort of where they have complex supply chains. I've worked very closely with other large MSPs just to understand what they're doing. Everyone's pretty much mirrored the same sort of governance and control rollout. So that was expected. We've started to see sort of rationalisation of umbrellas, in that these big MSPs have gone with what I would class a very narrow list, sort of 10 umbrellas that they want to use or less in some cases, and that appears to have started to rationalise the umbrella supply chain, I would say. But also we've seen a rationalisation of agency suppliers as well in the MSP space, and that's through natural rationalisation through those businesses not being able to adapt or financially be viable with the JSL change for whatever reason, but also as MSPs look to create those tighter partnerships with suppliers. They don't want 1,000 suppliers on their supply chain, because doing that audit control 1,000 times is a lot more difficult than doing it 20 times. And we've seen the increase in the amount of documentation and questions being asked around auditing, and we're asking those as well as an MSP. So those are the things that you would expect to see, I think, and they've happened. There's been an increased awareness of JSL definitely in the private sector. Some areas in the public sector where we service, there's still, I would say, some probably a lack of understanding to a degree, and there still probably needs to be some guidance released by various public sector bodies to guide that knowledge. I think so. Yeah, there's that, and in terms of what might still happen and what do I expect to happen that's probably missing at the moment. I think the next big thing will be some sort of enforcement by HMRC around JSL. That's going to create awareness. That's also going to ensure that everyone steps up their governance and controls, including end clients, including MSPs and agencies. And I think that's the bit that's missing at the moment, that we've gone live, but I suspect HMRC will quickly look to enforce at some point. And I think that links back to what Hannah was saying earlier around bills of exchange and that scheme sort of coming out, and HMRC quickly jumping on that and issuing guidance on that. I think they're going to want to quickly show that JSL has some teeth and they're willing to use it. I hope they do anyway. That's my hope.
Hopefully quicker than previous times. It tends to take quite a while, doesn't it, for that to actually happen in practice. But you mentioned the public sector specifically, and perhaps that been a little bit further behind than the private sector and needing further guidance.
Yeah.
Do you think, outside of your business, that there is then still some non-compliance within there?
Yeah, I think so. I think just when I've been networking with umbrella companies, we've been networking with other people in the industry. I think, and the bill of exchange coming out fairly quickly after JSL. I think there's a group of people that either are willing to avoid tax, or having to avoid tax because their business is built on that model. And I think that is still happening in the supply chain. To what degree, I don't know. I think where an MSP, private sector MSP sits, that's eliminated it. I genuinely believe that, because they are willing to invest in the controls and governance around that. But where an MSP doesn't exist and it goes straight into the end client, there may not be that increased governance and control that's stopping it. And you sort of hear stories about tax avoidance still happening. And I think that's clear. There was billions being made on the back of tax avoidance prior to JSL, that's not going to disappear overnight. And what I do think is there will be people that will be coming up with the next scheme that avoids or circumnavigates JSL somehow and be trying to sell that. And I think that will continue to happen. I think that's one of the key points for me that I've taken away. Any controls and governance that you've put into your MSP or your staffing business, or as an end client, that needs to be agile in nature. There needs to be a continuous feedback that you need to continue to strengthen and change those controls and processes in line with the way the market or the tax avoiders are moving, and making sure that your controls and governance keep up to speed with what's happening, because it's not just gonna stop overnight, unfortunately.
Yeah, it's not a one task once, right? It is continuous. And well, thank you everybody. I think that probably brings us to a bit of a natural end on the JSL piece. What we will do is at the end, we'll just take questions from the audience. But for now, I'm just going to move on to the Employment Rights Act. There's a lot of changes that are coming in as part of the ERA. It's obviously the biggest upgrade to worker rights in a generation. There's a framework in place, but we're obviously awaiting further detail on some of the major reforms. Some of those being things like introduction of the Fair Work Agency. We've got the banning 0 hours contracts and looking at guaranteed hours, payment for changes, cancellation and curtailment of shifts. There's a lot that's part of that ERA. Some of those consultations have already happened and closed. Some of those consultations are currently open. Hannah, are you able to give us a high-level summary of the ERA and what we've already seen and what we're yet to see?
Yeah, of course. So, I mean, the government, I think, quite optimistically produced this roadmap back when they released the Employment Rights Bill as it was then, and they've kept to some of it, but quite a lot of aspects of it are now starting to slip and may well slip further depending on what happens over the summer with our government. Um, in terms of the sort of headlines, because you're right, Alex, there are just so many legislative changes under the Employment Rights Act, but the ones that are particularly relevant to this sector that have already come in earlier this year, 6th of April, we saw SSP becoming a day one right, so removing those three waiting days, and also removing the lower earnings limit, so more temporary workers are eligible for SSP, and sooner. The introduction of paternity leave as a day one right, and then something that I'm sort of quietly excited about is the creation of the Fair Work Agency. I think it has real potential um, to bring about some of this enforcement that actually, compliant employers want. I think compliant businesses are a bit fed up of trying to compete with, their counterparts in the market who are avoiding tax, who are avoiding paying holiday pay, who are avoiding giving their employees their employment rights. And, from a worker perspective, you bring a claim in the employment tribunal now, you'd be lucky if you get a final hearing within 2 years. It's just not a way to go about trying to recoup, national minimum wage that's not been paid to you, or holiday pay or whatever. So I think the Fair Work Agency has the potential to really shake things up, but it really needs some proper resource. So we'll see what comes of that. In terms of sort of immediate changes, we will see the extension of the time limit for bringing employment tribunal claims from 3 months to 6 months. That's due to come into effect in October. So giving employees and workers a longer period to bring a claim after something happens. So the termination of their employment or a discriminatory act. At the moment, they've got to get that claim in within 3 months. That's being extended to 6. We're also anticipating, although we haven't actually got the draft regulations yet, but around October time, various changes to trade union rights. And you might think, well, it's not hugely relevant to my sector, but actually it could be. And I do think that umbrella companies and agencies, with large numbers of employees and workers on their books, could be a prime target for trade unions, because these changes that are coming into force are going to make it easier for trade unions to get access to those staff to effectively kind of market themselves. As an employer, you're going to become obligated to actively tell your staff about their right to join a trade union. So that could be quite interesting. 1st of January next year, We're going to see the length of service requirement to bring an unfair dismissal claim reducing from 2 years to 6 months. That's obviously significant both in terms of your permanent staff. It effectively means a less than 6 month probationary period, because if you think an employee is not a right fit for your business, you need to have taken steps to terminate their employment before that 6 month mark. Otherwise, you can still terminate employment afterwards. It doesn't mean that after 6 months you're sort of stuck with an employee forever. But you need to go through a more sort of onerous process of considering what your fair reason for dismissal is, going through a fair process. But the impact on this space as well of that could be quite significant when it comes to umbrella employees. Because, at the moment, I think it's probably fair to say the majority of umbrella employees tend not to be on an assignment for more than 2 years. So unfair dismissal is, not generally speaking an issue that comes up, but going forward, if an assignment is terminated after 6 months and there's no further assignment available for that worker, the umbrella company is going to have to terminate their employment. And it then becomes quite tricky, really, to sort of do a fair process and have a fair reason for dismissal if either the end client has already taken the decision to terminate the assignment for whatever reason, or just by nature of the fact that umbrella employees are sort of remote. They're not within your business. It's not necessarily easy to communicate with them. So that could be a little bit of a challenge. And then at some point in the future, if we're unlucky, we're going to get this obligation to offer guaranteed working hours and pay compensation for shifts which are cancelled at short notice, and an obligation to provide reasonable notice of shifts. And I say if we're unlucky, a little bit tongue in cheek. I mean, clearly the motivation behind that piece of legislation is to protect the most vulnerable workers, those who don't have, who are on, say, a 0 hours contract, who have no predictability of working pattern, no predictability of wages. Clearly, something needs to be done about that. But from my perspective, this does feel a little bit like a sledgehammer to crack a nut, and the sort of administrative process of having to offer every single agency worker on a sort of rolling basis a contract guaranteeing them a fixed number of working hours is going to be a real challenge, and it's an obligation to offer it to them, and then they have the right to bring a claim if you haven't made that offer. It's not a right on their part to request it. So there are going to have to be active steps which the parties in the supply chain have to take. The proposal at the moment is that offer of a guaranteed hours contract has to be made by the end user client. So at the moment, you've got an agency or an umbrella company employing or engaging the worker. They're then going to have to move across into the end client's employment. I mean, there's a question about their status, whether it's worker or employee. But I mean, clearly, this is fundamentally contrary to the nature of contingent workforce. In that, from the end client's perspective, that they're outsourced. So we don't have the draft legislation yet, so I don't want to go sort of too into it, because I'm really sort of keen not to be, the bearer of doom and gloom and to scaremonger when we don't have detail yet, and whenever there are legal changes, even ones which, the sector are nervous about, we find a way through. I think the sector is highly resilient. But as you said at the start, Alex, there's an awful lot going on. We've just got our heads around JSL, broadly speaking, and then we are going to have to try and get our heads around guaranteed working hours and reasonable notice and compensation for shifts. That consultation is still live. It is live until the 25th of August. And if there is one thing that you take away from this part of the webinar, I would say it is please to respond to that consultation, whether you are an umbrella, an agency, an MSP, and indeed end user clients, because as I've said, they are absolutely going to be impacted by this. And I think there are lots and lots of questions that the government haven't really applied their mind to, and how, in terms of how this is actually going to work in practice. So the more voices that respond with kind of good quality data and statistics, and not just sort of general grumblings about, oh, I, don't want to do this. If you respond to that consultation, even if you only pick out a couple of key questions, but really provide your insight as a business, as a supplier or user of labor, into, how this could potentially work, and areas that the government hasn't considered, that will be hugely valuable in shaping what that legislation looks like.
Chris, if we stay on the 0 hours and guaranteed hours piece, do you want to give
Mhm.
your take on that? I know like the consultation's positioned as ending one-sided flexibility, but in
Mhm.
practice, do you think this rebalances the labour market or actually risks reducing flexibility altogether? And what's your take?
I think the intent really is to rebalance as opposed to end, if you like. My take is first and foremost on Hannah's point. Please respond to the consultation. Yeah, it's quite key ultimately. Having read the consultation and kind of the information that's around that, there does seem to be some kind of acknowledgement of the differences between directly engaged and agency workers. But we were talking yesterday, Charles, in terms of your area and direct engagement within the NHS, clearly not been considered here at all. But there's lots of key components that need to be addressed, and as Hannah said, just pick out those points in the consultation. From an umbrella perspective, obviously this is quite key, and we from our understanding and conversations that I've had via FCSA with DBT, umbrella workers do seem to be seen as agency workers. Okay, it's not finalised, as Hannah said. We're waiting for the final detail, but as part of the overall process, they are looking and have confirmed that in circumstances where someone already has guaranteed hours, then they would kind of sit outside of these changes. And key to that is obviously with an umbrella company, a genuine compliant umbrella company, I may add, is that there is always an offer of guaranteed hours, which is an annualized amount. With Sapphire, it's currently 336. Some companies is slightly higher. We need confirmation and detail in terms of the weekly hours that the government will land on and the reference period. But ultimately, our view is that that may be a way of not getting round it. We're not talking about JSL and trying to get around it, but a recognition of what umbrella companies offer in the supply chain. And the other part of the ERA framework is obviously the formal recognition and definition of umbrella companies as well, Alex. So that, for me, having been doing this for so many years, is bittersweet, if you like. It's finally some kind of recognition that we do a good job. We are kind of central to the supply chain, but it brings with it some challenges as well. Some of the being recognised and formally regulated means that we will be seen as employment type businesses. So that has a knock-on effect with regards to conduct regs, as an example. What it also means is that we'll be brought under the auspices of the Fair Work Agency. So, we have a super regulatory board or agency that's going to be going out and looking at, on the agency side, those companies that effectively have not been compliant over the years that frustrate the hell out of us all, and the same on our side as well, looking at those minor details. And just in the last week, I've spoken to two agencies that have already had letters from the Fair Work Agency. Yeah, that are wanting to engage. They're wanting, it's the same information. They want key information documents. They want engagement contracts. They want to see exactly what's happened throughout the whole supply chain. As you'd expect, I'm looking at those and going, we have supplied all these, and we know the agency have got all these. But it's that same frustration, is that there's always been, and most people that are on this have joined into this call will be part of that cohort that have been doing this the way in which it should have been for many, many years. I'm hoping that the Fair Work Agency and us being kind of, and the umbrella industry being regulated by them, will weed out all of that non-compliance, and ultimately put us all on a level playing field, basically.
Yeah, I know of an agency that's actually already had a visit from the Fair Work
Mm,
Agency, which is
yeah,
obviously pretty quick to action,
yeah.
which is interesting to see. Charles, I suppose the creation of that agency is going to centralise enforcement. Do you expect this to materially change compliance behaviour across the whole supply chain?
Yeah, I mean, I think it will do, but probably not overnight. I think, as we've seen with other things, sort of JSL and other changes. My gut feeling is there needs to be really strong communication around what they do, how they're going to do it, and how they're going to add value. And also, then there has to be maybe a degree of enforcement. It sounds like they've come out the blocks pretty quick, which is great news. I think the change in compliance behaviour, as Chris sort of alluded to, there's a large group of people that are already doing the right stuff. So they're probably not going to change, but they'll just have to elevate their ability to evidence. I would have thought, and then you'll have a group of people that are non-compliant and will probably try and remain non-compliant for as long as possible. And I think that's the key. Why I sort of said the degree to which they change the behaviour will be determined on their ability to articulate and communicate and be visible and also enforce. I think ultimately their ability to do all that will be judged or determined, through the resources they're given, the access to data that they have, and their enforcement appetite to follow up on issues in the supply chain. But I think having that one centralized agency should, in theory, make enforcement more visible. It should be more coordinated, and I think it'll be easier for all of us, whether we're agencies, umbrellas, workers, clients, to understand what's happening, why is it happening, and what's the sort of outcome, I guess, through that agency. So I think I'm hopeful that this will allow better coordination and a more focused effort.
Makes sense. Chris, you mentioned the Fair Work Agency before, and obviously the regulation of umbrella companies. And you mentioned a couple of the impacts that will have. There was obviously the consultation recently, which obviously we've submitted a response to, and that one's now closed. But are there anything that you'd want to pull out of that latest consultation to discuss with us today?
I think so. We're talking about the guaranteed hours consultation here, yeah.
The umbrella.
The regulation of the umbrella company, yeah. So I think it's as I said, it's quite key to understand that we're still waiting for more detail. They were expecting that potentially to come in next year at some point. When that comes in, then umbrella companies will be or won't be allowed to opt out of the conduct regulations. That in itself is something that agencies have kind of relied upon for many, many years, but we have seen a kind of a sea change in respect to that in the last couple of years, where it's understood that obviously takes away workers' rights. I think it's a really, really good opportunity for umbrella companies and agencies to collaborate and engage with their own clients in a similar way as to what we saw with I-35, Alex, where umbrella companies became useful in being the subject matter experts in and around I-35 and being able to explain that as well. It's going to be important for on the back of that for everyone to understand their place and to enforce transparency throughout the market, I suppose, as well. So again, that point just needs to be thought through, and I think we'll be hoping to lead the market in this in terms of engaging with our agency partners as well.
What's your thoughts on that, Hannah? Do you think umbrellas coming into regulation with that Fair Work Agency, do you think that's going to reshape the agency and umbrella relationships? How do you think that umbrella regulation is going to change the market, if at all?
I mean, I agree with everything Chris said. I think the sort of broadly the removal of the ability to opt out if you're engaged through an umbrella company is going to be quite significant. And I think, with all of this, you sort of need to look at all these proposed changes. You can't look at these proposed changes in isolation. They all sort of interlink with each other. So, look, one of the benefits, if we can put it this way, of being able to opt out of the conduct regulations at the moment is that there isn't an obligation on the employment business to pay the worker when the end client hasn't paid them. If the worker is no longer going to be able to opt out of the conduct regulations, then that sort of exclusion won't apply. And in any event, one of the aspects of the consultation which is being looked at is essentially, removing the ability of umbrella companies to pay when paid. So, all of this sort of interlinks, it affects cash flow through the supply chain. And a lot of this, it makes its way back to the end client. As I said before, it's about cash flow, it's about cost, it's about credit terms, which credit terms perhaps not, but a lot of this is being driven by the end user client. So coming back to what both Charles and Chris have said, I think it's just ever more important to try and open those communication channels, and share data and share insights, and to just try and be a little bit more aligned, because I think, it is no longer the case that the umbrella company just sits at the bottom of the supply chain and sort of deals with the hand it's dealt. There's liability flowing up the chain, and there are fundamental shifts in, that affect the commercial realities, as I say, around sort of pay when paid, cash flow, credit terms. This is all being looked at, kickbacks. Um, it does have the potential to quite fundamentally alter the way in which the supply chain operates. So yeah, as Chris said, I think it's an opportunity, a real opportunity to, get in front of your partners in the supply chain, wherever in that chain you sit, and try and open those doors and have those conversations.
Yeah, I
Just going
think
back, oh, sorry, Alex. I was just saying, going back to that leveling the playing field, is that the opportunity comes with those agencies that have been forcing down rates, yeah, and margins, etc. Because this will bring with it transparency right the way through, effectively. So you would have seen it in your area, Charles. And no doubt, lots of people on this call would have been undercut in certain circumstances, and you're kind of trying to understand how and why. And from 2021, as part of the conduct 2020, I should say, as part of the conduct regs, key information documents needed to be sent, and just looking at the names of people on this list, I know that those agencies are doing that, but there's lots of agencies that aren't. Yeah, and that sometimes is due to apathy, but it's also down to the fact that they can't be transparent in providing that information as well. So again, just that they are looking at key information documents as part of this, aren't they, Hannah, as well, and whether they need to be updated, changed, etc. Who needs to provide those? But as I said, this will bring with it transparency, long needed transparency, which will hopefully again weed out those players that shouldn't be there, basically.
Yeah, I think it just demonstrates, doesn't it, that how important it is for all stakeholders within the supply chain to feed back into these consultations, because
Yeah.
they could be positive for the whole supply chain, or they could not, depending on what information is fed back to the policymakers to help adapt the legislation in a way that is workable for everybody in the recruitment space as well as the umbrella space. So, which I suppose comes onto one of my last questions. Start with you, Chris, I suppose. What should agencies and clients, MSPs, be doing now to ensure that they're not commercially or operationally exposed to some of these reforms that are going to land?
I think it's the key message that we've said, is that I think that they need to be getting up to speed with what ERA is going to present. I think we'll be playing a part. The reason why we've got this webinar today is to put it front and center. So yeah, make sure that you're aware, bring in trusted providers and advisors to help you with that, and get to the table with your end clients, because we're now in July tomorrow. Some of these proposals are less than 12 months away, and coming in. So that's not a necessarily long lead-in time, and they are quite fundamental. So the sooner you start having those conversations, the better. And I can't say it enough. Respond to the consultation, get your own clients to respond to the consultation. Just by reading the consultation, I think you'll get an understanding of why this is important, basically. But that's my advice: respond.
Charles or Hannah, have you got anything else to add on any of those points?
Do you want to go first, Hannah?
I was just going to say exactly as Chris said. It is so worth the time to respond, because this does mark a potential shift in the market, the structure of the market, and the sort of commercial relationship. So absolutely worth your time in responding. And yeah, again, I'm banging the drum about just opening those communication channels and just enabling a freer flow of discussion and data.
Yeah, and I
Charles?
think just yeah, actively engage in the consultation. I think, seek other opinions that aren't just in your own business or your end client. And what I mean by that is, get out there, network, go to some of these webinars. There's always lots of stuff on where you can do in people workshops, and I found that really helpful, especially when working through some of the JSL challenges and just understanding how other people are thinking, and feed that back to your business, feed that back to your end clients, and link that in with the kind of the engagement in the consultation. And I think, where you can use trade bodies to help you understand what the market's thinking and potentially lobby if you need to as well.
Right. I suppose we've obviously touched on quite a few different elements of the Employment Rights Act there, and it's obviously really, really detailed. So a couple of things from me. Chris, having joined Sapphire very recently, he is keen to meet as many of our clients as possible. So if you'd like a deeper dive on any of the sections that we've talked about today, I know that Chris is more than happy to set up Teams meetings with our clients directly. We're going to add a link into the Q&A section for the 0 hours consultation piece that we've all been telling you to feed back into, so you can't miss it. So that will be in the Q&A box. And then lastly, if you would like to hear more specifically on that point, the FCSA are hosting a webinar themselves on the 6th of July at 1 p.m. Around the consultation. So there'll be further detail there as well if you want more information from FCSA. And as Charles said, I think over the next few months, there's going to be continuous webinars, forums, networking events where these topics are up for discussion. And whilst we might not all find it the most riveting at times, there is definitely going to be an impact on the whole supply chain with these changes coming in. So it is really, really important that we do all engage so that we end up in a position that's positive for the sector and not negative. I am done there. So what I was going to do is see if we've got any questions from the audience. And we do. So let me just have a quick read of this and then I will read it back. I'll just read it out. I'm interested in understanding how you manage suppliers in the supply chain that were not willing to comply. What steps did you take to bring them into compliance? And if those efforts were unsuccessful, what actions did you ultimately take? Charles, that's one for you for sure.
That sounds like a Charles question.
Oh.
Yeah. I mean, it would immediately ring alarm bells if there's a supplier that's not willing to comply with the sort of the controls and governance you put in place, because every single MSP is doing that for joint several liability. That is standard practice. That would straight away make me think they are doing something that could create risk for you as an MSP. So what we did practically was we gave suppliers time to share the information we required to audit them and make sure they're using our umbrella PSL. And as long as they were taking those steps to share that data, we worked with them if there were challenges around, data alignment or quality. But where there was instances where a supplier was totally unwilling to work with us and to comply with the rules that we set, then what we would do is remove them from our supply chain. The risk is too great for us as an MSP to allow a supplier to operate in our supply chain where they're not willing to provide visibility. And we took quite a sort of hard line, and I know other MSPs have done the same thing as well. And we shared that information with our clients when we had to take that action, and our clients are understanding as well, because we've spent time sort of bringing them up to speed with what JSL means for us as an MSP and the broader supply chain. So I think in my view it comes back to the piece around having a supply chain that you have really deep partnership with, so you can have those proper conversations. And if they don't, I think, make sure your supply contract is strong enough that you can take the action to remove them where they're creating risk for you and your end client as well.
Perfect. One more here. So in relation to the Employment Rights Act changes on unfair dismissal, can you clarify whether these protections will apply only to workers employed through umbrella companies, or whether they will also be extended to temporary agency workers who are employed and paid directly by the agency, so agency PAYE? Hannah, do you want to take that one?
Yep. So the changes apply to anyone who is employed on a contract of employment. So umbrella companies generally operate an employment model, so it will apply to umbrella employees. If you're operating agency PAYE on a contract of employment as opposed to a contract for services, then it will apply to those agency workers, and obviously it will apply to your internal staff as well.
Chris, have you got anything to add to that one?
No, I think that's exactly what I was going to say. I suppose that if you're employed, and there are lots of agencies out there who do employ their workers, they're not just seen as live workers, and sometimes they're not necessarily aware of that circumstance. So, very good question. But yeah, same as Hannah, I suppose.
Yeah, the joys of contract of and contract for services. Just
It's a murky world.
keep it nice and to keep it nice and clear, or use very, very similar terminology. It'll be interesting, won't it, with agency pay as you earn, I think, over the next year, and actually what the appetite is of the supply chain to either increase, decrease, or maintain those pay as you earn levels, because some of the changes increase cost and risk. Some may, slightly remove some, if depending on whether it's contracts for or contracts of. So, I think that's going to be really interesting to see how that plays out, to be honest, over the next 12 months. That is it for questions, unless anybody else has anything burning that they want to ask us. I don't think we could have done that much better time-wise. So thank you everybody for joining us. Thank you to our panelists, Hannah and Charles, for joining Chris and I today. Really appreciate everybody taking the time. There'll be a recording which we'll send round as well. But if anybody's got any further questions, then feel free to reach out to any of us directly. Thanks, everyone.
Thanks, everyone.
Thank
Take
you.
care.